David Makhura has denied any involvement in the multi-billion-rand personal protective equipment scandal. Makura and former Health Department Chief Financial Officer Kabelo Lehloenya have submitted their version of events to the Special Tribunal. To talk more about this, we're joined by the Tribunal spokesperson, Makhura. Advocate Makhura, good evening to you and thanks for your time. Firstly, I suppose not surprising, the defense of the Premier in terms of dismissing these allegations. They were surprised to have even been invited as a third party.
No, thank you very much, Kathy. Good afternoon to the viewers. Thank you for having me. Indeed, based on the heads of argument that were sent to the Special Tribunal beforehand, before today's hearing, they disputed their inclusion, the Premier, the Provincial Government of Gauteng, as well as Professor Lehloenya, the former head of department. They are strongly opposed to their inclusion into the proceedings. So through their legal representatives, they asked the Special Tribunal to strike out their inclusion as an irregular procedure. What gave rise to the proceedings is that Ms. Lehloenya was supposed to be on trial this week, but there were these preliminary issues that she included, that she filed with the Special Tribunal, that need to be ventilated and clarified before we went into the main proceedings. That is actually the main trial. So the long and short of it is that today the hearing had various arguments, but ultimately judgment has been reserved. Ms. Lehloenya is of the view that the Premier should be held liable both in his personal and official capacity, and that there were quite a number of allegations and defenses that she raised to that effect, but the Premier is opposed to the application.
When we look at why they were dragged into this matter in the first place by Kabelo Lehloenya, ultimately, the tribunal is going to have to make a call on whether the grounds in which they've been invited as third parties are actually valid. What kind of criteria is going to be used to determine that?
Well, there must be merit in the application, in the argument by Lehloenya to the effect that the Premier private and official inclusion into the pleadings, into the proceedings, should have merit. So based on the evidence on record is what is actually ultimately going to guide and direct the Special Tribunal as to the type of finding. I think what we need to clarify is the fact that the trial for Ms. Lehloenya was, and Professor Lehloenya, they are co-defendants in the main application. So they, Ms. Lehloenya in particular, is of the view that before we could go into the main trial, she needs to have these issues ventilated. So what is actually going to give the judge the final determination is the evidence on record, the arguments that she had today, and the evidence before her.
When the CFO, again, Lehloenya, that is still set to stand trial, names the Premier, on what grounds do they believe the Premier should be partly responsible for whatever financial liability that may come out of this hearing? So what is he alleging the Premier did?
In the main, she alleges that the Premier had abused his office. The Premier ought to have exercised caution and give guidance. In fact, he should have played a role in ensuring that there was no suffering financially or loss to the state in the procurement of the personal protection equipment. She further alleges vicarious liability. In her contention, she argues that she was doing this in the scope of her employment. That is another issue that was heard today. And the employment issue, the breach of the contract thereof, she's challenging that because the Premier's response to the allegation is that Ms. Lehloenya has lost state protection by allegedly being involved in the form of wrongdoing. So Ms. Lehloenya's contention that the Premier, the provincial government, as well as Professor Lehloenya, need to be included for joint liability as both joint and concurrent wrongdoing is being challenged. So in the main, Ms. Lehloenya's argument is that the Premier should have exercised his official responsibilities, more so that he is the overseer of the provincial administration, and as such, Ms. Lehloenya is of the view that any amount that the special tribunal seeks from her, she should have some form of indemnity or any form of contribution by both the Premier in his personal and official capacity, as well as the provincial government of Gauteng.
Has there been any mention at all of the former health MEC, Dr. Bandile Masuku? Because one would think that if the Premier is seen as somebody who is liable, the individual who was directly responsible for overseeing that department from a political figurehead perspective was the former MEC.
In this particular pleadings, no, there is no mention of the former MEC, but there was a question that was asked by the special tribunal to the parties, mainly to the lawyers, to say, who exactly are we referring to when we say the provincial government of Gauteng? Who exactly? Because the provincial government is composed of the Premier being the head of the executive, as well as the members of the executive council. So there was no clear indication. Our observation was that the parties had actually not taken issue on that. So, but to answer your question specifically in relation to Dr. Masuku, before the special tribunal, we do not have his name.
When can we expect an outcome?
Well, what is going to happen is that the presiding judge is going to hear the arguments. Having heard the arguments, he's still going to consult the law. There were various cited cases that have been decided relating to vicarious liability and wrongdoing. And at the end of the day, we do believe that in the next few weeks, judgment will be available.
All right, let's leave it there for tonight. Advocate Selby Makura there. He's the SIU Tribunal spokesperson.